everyone. My name's Diane, and I am a library aide at the Blackstone Public Library located in Blackstone, Massachusetts. I'd like to welcome everyone to the first of several Zoom presentations as part of the Blackstone Public Library's Financial Literacy for All Ages, a Formula for Success grant. This program, Wills and Trust and Deeds, Oh My, is brought to you with federal funds provided by the Institute of Museum and Library Services and administered by the Massachusetts Board of Library Commissioners. We have several dozen attendees for today's program, so I will be muting all guests during the presentation and ask that you hold all questions until the Q&A session at the end of the program. If you do have a question at the end for the Q&A session, please indicate this by raising your hand using the raise hand symbol on the Zoom participants window. Again, you can find this by opening the participants window for your Zoom program. At the end of the presentation, I will scan for the raised hands. Please have patience as I call on you one at a time. I will unmute you and call on you and ask you for your question. Next, please let me introduce our presenter, Lynn Bouvier Kapiskas. Lynn is an attorney in the law office of Mark L. Smith in Woonsocket, Rhode Island, where she has been employed for almost 34 years. Lynn is a graduate of Providence College and Suffolk University Law School and is licensed to practice law in both state and federal courts in the Commonwealth of Massachusetts and the state of Rhode Island. Now, without further ado, let me pass this over to Lynn to start the presentation. Lynn, take it away.
Good evening. My name is Lynn Kapiskas, and our presentation today is on wills, trusts, and deeds in the Commonwealth of Massachusetts. And I'll just start with some, and it is going to be a basic format, but I'm willing to answer any questions you have in more detail. But I'm trying to make it appealing to as many people as possible. What is an estate plan and why do I need one? An estate plan is a plan made up of a group of legal documents that set out what happens in mainly two instances. The main one is what happens when you pass away, but there are also some related documents for what happens when you can no longer take care of your own affairs or your own estate. Who needs an estate plan? Everyone should have these documents in place, no matter how small your estate, so you can be assured that as to who will help you manage your affairs in the event you're incapacitated, or who gets your estate when you pass away. Do I particularly need an estate plan? So we're going to go through a couple of different scenarios. If you own anything, a house, car, stocks, bank account, boat, in your own name, your estate will have to be probated if you die with them in your name. Without an estate plan, Massachusetts probate law determines where your estate goes at death. Despite what you may think, everything does not necessarily go to your surviving spouse, and that's an important thing that people don't understand. With an estate plan, you can control who's in charge and to whom your estate assets go at death. Some people say to me, well, I'm too young to worry about that. No one's too young. If you own anything, you need to think about this for the orderly passage of your estate when you pass away. Also, the amount of your estate has nothing to do with whether or not you need an estate. No matter how small or large your estate is, there's an estate plan that's suitable to handle your particular situation. What is probate? When you die, everything you own is owned by your probate estate. So in other words, anything that's owned by Lynn Kapiskas at the time of my death becomes owned by the estate of Lynn Kapiskas. Where it goes from there depends on your estate plan or your lack thereof. If you have a valid will, your will, once it's admitted to probate, will control who's in charge and where your assets go. This is especially important if you have minor children. Essentially, if you provide in your will that everything goes to your minor children, it will go to your minor children. If you have a 6, 7, or 8-year-old, that's probably not a big deal because whoever has custody of those children is going to manage those funds for them. However, if you have a 14, 15, 16-year-old child and the assets go to them, they're not going to be so amenable to whomever having custody of them managing their affairs. They're going to want that money themselves. Also, in a will, you can indicate who would be the guardian of those children at the time of your death. It's not binding on a family court, but it's a pretty good indicator to that court who you would want to take those children in the event something happens to you. And that's an important thing to have some say in, because when you're no longer here, it's going to be up to someone to file a petition to take custody of those kids, and it might not be the relative you want. If you die without a will in Massachusetts, excuse me, the Massachusetts Uniform Probate Code determines where your assets go, not you or even your wishes as you might have stated them to your family. Now, a little bit of probate vocabulary, because Massachusetts probate is a little different than Rhode Island, and Rhode Island has the more traditional terms. The Massachusetts Uniform Probate Code uses words that are a bit different than we might normally use. The deceased person is referred to as a decedent. A person who dies with a will is referred to as testate. A person who dies without a will is referred to as intestate. Those are pretty uniform to most states. This is where the terms change though. In Massachusetts, they use the term personal representative in place of an executor if you die with a will, or an administrator if you die without a will. The reason for that is that the term personal representative is gender neutral, and that's part of the purpose of adopting the Massachusetts Uniform Probate Code, to eliminate those references to gender. The successor are the people who are entitled to receive your estate either by will or under the intestate succession law, the Massachusetts probate law. Most states refer to them as beneficiaries, but the Massachusetts Uniform Probate Code refers to them as successors. Just so you can understand, the Massachusetts Uniform Probate Code is essentially Massachusetts adopting the Uniform Probate Code that is recommended by a bunch of lawyers who sit in a room and say, this is how it really should be. It would make it easier for all of us if it was uniform. And they try to convince each and every state to adopt it. Massachusetts has adopted it. I believe there are about 28 states that have now adopted the Uniform Probate Code. Massachusetts is one of them. And it's relatively new in Massachusetts. When you think about probate law being archaic, it's only been adopted in Massachusetts for about the last 7 years. So that is fairly new. What happens when a person dies? Well, when someone comes in to see me and says, Mom died, Dad died, what do I do? First thing I ask is, do they have a will or a trust? If they have a trust, then the trust would set out who takes control of the trust assets for the purposes of marshaling those assets, gathering them together, distributing things in accordance with the terms of the trust. If they had a will, just because someone has a will doesn't mean that automatically the person named in that will as a personal representative or an executor has the authority to step in and take over. First, that will must be presented to the probate court for its authorization. It gets presented in Massachusetts to the probate court, it's actually the probate and family court, for the county in which the decedent died domiciled. Domiciled is a little more than where they died resident. Domiciled is where you're registered to vote, where's your car registered, the address on your license or your state ID. So it's a little bit more the location where you actually have a tie or a connection to. If they had assets, that will would be filed with a petition to probate the will, which would then have the will admitted to probate and the nominated executor named as their personal representative. The initial filing fee for petition to probate, and I'll get into the costs in a little more detail later, is $390 in Massachusetts. If the person had no assets and there is no need to probate their will, which is not uncommon for some people who might die in a nursing home, the will should still be presented to the county probate court for what we call safekeeping, because there's a requirement in the law that every will be made available for anybody to inspect. So as a result, there's a system in place for you to file a will in the probate court for safekeeping, and there's a $75 filing fee associated with that. Does everybody comply with it? Heck no, most people don't even bother. But it is a requirement under the Uniform Probate Code that the will be filed with the court for safekeeping so anybody can view it. If the person died without a will, but they had assets, a petition must be filed with the probate court to determine who's going to be in charge, who's going to be that personal representative, and to determine who gets what. Who's in charge and who gets what if you die without a will? If you have probate assets in your own name, but you are no longer alive to deal with, the personal representative, a PR, is appointed to take charge of those assets for either the sale of those assets to pay your bills or the distribution of those assets in accordance with Massachusetts intestate succession law. Now there's a chart in Massachusetts, an intestate succession chart. If you look at my speaker, you can see this is the chart. And if you're not happy with that, there's this lovely little chart too. You need to be a genealogist to understand them. So essentially there are books that will tell us exactly how the intestate succession law works. But I'll give you the shorthand version, which is what most people are going to be dealing with. If a person dies with a spouse and children, their assets go to the spouse and children. You might say, hey, that's how I wanted it to go. Well, quite frankly, that's usually not how most people want it to go. They usually want everything to go to their spouse first. And then when their spouse passes away, everything passes to their children. This becomes complicated if a person dies without a will with a spouse who's a second spouse and children from a first marriage. That may be for the benefit of the first children of the first marriage, but it's certainly to the anger of the second spouse. So that's why people, especially people who have children from prior relationships who get involved in a subsequent relationship, should have a will, because the intestate succession chart may not lead you where you want it to go. Person dies with a spouse and no children, everything goes to the spouse. They die with children and no spouse, everything goes to the children. If they don't die with no spouse and no children, believe it or not, it goes up to the surviving parents. It goes up and down generationally, grandparents, parents, grandchildren, grandparents, up and down. There's a little quirk at the grandparent level, but essentially that's what happens. And when I talk about leaving things to children, if one of those children predeceased the person whose estate is being probated, that person's children takes the child's share. So if I have two children and one of my children passes before me, when I die without a will in Massachusetts, the share that my son would have been entitled to would pass to my son's children. And that's to prevent what they call a lapse in inheritance. Costs of probate, this is the blood and guts, what everyone always wants to talk about. If you die with a will, there's a filing fee for a probate petition, that's $390. On top of that, you're typically required to file at least one advertising. Why does it have to be advertised if you died with a will? Well, there's a reason for that. An estate has to be advertised usually for two reasons. If you die without a will, it's advertised to give notice to all of your heirs that you've passed away. But if you die with a will, there is one advertisement that has to be made so that someone knows who's appointed as your personal representative. The reason for that is so that any creditors to whom you owed money who see that notice know that the time has come that they need to file a claim in your probate estate in order to get their whatever's due to them under the debt that you owed. Creditors have 1 year from the date of your death to file a claim in the probate court. People play games with that and try to file in the 11th month. I guarantee you the court's going to give a creditor time to file claims. But that's why there's an advertising. That there's at least one advertising in every probate. And the cost of advertising, quite frankly, depends on the locality in which your estate is being probated. In smaller cities and towns, and there are smaller populations, you can advertise in them more cheaply. If you die in Boston and the advertisement is in the Boston Globe and potentially the Herald, those costs can be exorbitant. I just had an estate where I advertised in a Whitensville paper, and excuse me, the fee for advertising was almost $400, which shocked me. In Rhode Island, those are generally under $100. On top of that, probably the biggest expense of probate is counsel fees. If you retain an attorney to assist you in the probate of an estate, you can anticipate fees at about $2,000. In a normal estate, you might get some that are going to go lower than that if everyone's cooperative, not a lot of assets, not a lot of work involved. But most Bar Association journals will tell you that the estimate for how much legal fees are going to be in just about any estate is anywhere between 3 and 6% of the estate's value, because the estate's value determines how much work has to be done in order to resolve it. However, I want to clarify that it is unethical for an attorney to say, I'll handle mom's estate, you're going to give me 3 to 6% of the estate's value. That's illegal. It has to be charged as either a flat fee or an hourly fee. We can't do percentages or contingencies in probates. That's considered to be unethical, because you could have $1 million estate in which there's 2 assets and the estate is concluded with the stroke of 2 pens. So that is not how it works. In an intestate estate, same filing fee to file a petition for probate, $390. Advertising fees doubled. As I indicated, is one, when somebody gets appointed as the personal representatives, the creditors can file claims. But there's a second one, so you can give notice to any heirs who might be entitled to receive anything from the person's estate. You are also required to give those heirs notice by mail, and if they are agreeable, to sign a waiver to allow the petition to go forward. But if there's somebody that you can't find, or somebody that's unwilling to sign that waiver, that second advertisement is going to play. So the advertisement cost is going to double. Again, counsel fees average about $2,000, but most estimate these will be between 3 to 6% of the estate's value by the end. In addition, in an intestate estate, when someone dies without a will in Massachusetts, or in Rhode Island for that matter, and you own real estate, if that real estate is to be sold and not actually given to somebody as a beneficiary of the estate through means of a deed, to sell it, you have to get court permission. A well-drafted will will include the authority to sell real estate. But if you have to sell it in a will, in a state where there is no will, you need court permission. It's a sliding scale fee based on the value of the property. Starts at about $100 and goes up to over $1,000, depending on the value of that property. And on top of that, you usually have to support the petition to sell with an appraisal to demonstrate that it's worth what you're selling it for. In other words, to prove to the court that you're selling it for $100,000 and it's worth $100,000, not $150,000. Estate taxes. People always worry about them. Most people don't have to worry about them. Estate taxes are paid out of the estate's funds. They're not paid by your heirs. They're not, other than their distribution might go down. They're not paid by your executor. They're paid out of the estate funds. In federal estate tax issues, no taxes are owed unless the value of the estate exceeds $11.58 million. That's this year. And as I always say to my clients, gosh, I wish I had that problem, but I don't. Massachusetts estate taxes. In Massachusetts, there's an exemption for estate taxes for estates that are below $1 million. So unless the value of your estate exceeds $1 million, you do not owe estate taxes in the Commonwealth of Massachusetts. I have to tell you that that is on the low side for most state estate tax requirements. In Rhode Island alone, your estate only owes estate taxes if it exceeds $1.58 million. At $1 million, Massachusetts is on the low end, and there are very few states that are that low at this point. Lobby your legislature. Taxable estate. What is included in the taxable estate? Your real estate, and that includes the whole value of your real estate, even if you own it jointly with somebody else, like a spouse or a sibling. Your bank accounts, your stocks, your bonds, your cars, your boats, your private planes. Life insurance proceeds are includable if the person whose life was insured was also the owner of the property. So in other words, if I bought a property from ABC Insurance and I paid the premiums on it and it insured my life, the proceeds of that policy, even if they're going to somebody else, they're not part of my estate, they go to a beneficiary, is still includable in my estate for tax purposes. And for estate tax purposes, so is your retirement account. And quite frankly, right now, we are now reaching deaths in a generation where there's been significant contributions to 401ks and IRAs. So that becomes more of an issue and is going to push a lot more of estates into the taxable category in a lot of states, particularly in Massachusetts. What happens if your estate in Massachusetts is worth less than $1 million? You don't have to file an estate tax return, but Massachusetts, as does every other state with an estate tax, puts an automatic statutory lien upon any real estate in which the decedent has an interest to make sure that they have a means to collect those estate taxes when the person dies. To discharge that lien, and you want to discharge that lien as part of the probate process, the personal representative must prepare and record in the county where the real estate sits, may not be where the person's estate is being probated, but where the real estate sits, an affidavit that no estate taxes are due and owing, that the estate's worth less than $1 million, and a certified copy of the death certificate. There's a recording cost for each of those of $79. Why do you want to discharge that lien? Because you're going to be unable to sell that real estate or transfer that real estate or borrow against that real estate until you discharge that lien, because that lien creates what we call a cloud on title, same as if it was a mortgage. It has to be resolved before you can pass clean title to the next person. And I usually recommend that you do it at the time of death while the probate's going on. And, you know, mom may say, I'm not going to sell the house. It's not an issue when dad passes away. Don't go by that, because otherwise 6 years later, when mom dies, you're going to have to be doing dad's estate taxes to get that lien discharge. They'll be trying to reinvent the wheel. They're trying to remember what was the value of these assets 6 years ago. It's much easier to just do it now. What happens if your estate is worth more than $1 million in Massachusetts? Well, first of all, good for you. But you do need to file an estate tax return. Any estate asset that passes to a surviving spouse passes estate tax free. So in other words, if dad's estate is worth $2 million, the entire estate is worth $2 million, it all passes to mom tax free when dad dies, even though it's a $2 million estate. So sometimes when you do estate planning, an attorney is going to talk to you about a more complex estate plan to provide for what they call a marital trust and a family trust. So that essentially the first $1 million passes to the family trust, to the kids. You take advantage of that $1 million exemption. And then the rest passes in the marital trust to mom, because everything that passes to mom is tax-free. So just so you can be aware, if someone talks to you about that, that's what they're talking about. Unless your probate attorney is also an accountant, my suggestion is always engage an accountant in the preparation of your estate tax return, because they're going to be far more familiar with deductions and things that may assist you in bringing that estate to a non-taxable level. On its face, it may seem that there's more than $1 million, but an accountant who knows the law, knows the tax law better than any attorney is going to do, may be able to bring it in at below the $1 million level and save you some money. So it's worth engaging an accountant. If the decedent had a regular accountant, I usually suggest that you retain that accountant, because they're going to be familiar with that person's actual assets, what the value of the assets are, whether they've been capitalized and such. And again, those estate taxes, as well as the accountant fees, would be paid out of estate funds, never paid by you as the executor or personal representative, and never having the heirs dig into their own assets to pay. But do my heirs ever have to pay taxes? Well, in Massachusetts, there is no inheritance tax upon an inheritance. And that's true of most states. There's about 8 states that impose an inheritance tax. Neither Massachusetts nor Rhode Island impose an inheritance tax. Nor is there an income tax assessed on anything that they inherit, unless they inherit an asset which is tax deferred. Excuse me, the prime example of that is a 401k. You might name your child as the beneficiary on a 401k. You're not paying taxes on the interest income that's earned in a 401k or an IRA. So those are considered tax deferred. So when those assets actually pay out to your child, there is going to be an income tax assessed. They're going to get a 1099 for that distribution. If it passes through the estate, they're going to get a K1 for that distribution that will be reported on their own tax return, unless the decedent actually reports it on their return and pays the income taxes themselves. The bottom line is an asset that's tax deferred is never tax exempt. Or as I always like to say, the king always gets his crown. He gets his coin too. So where do you begin if you want to do an estate plan? My first suggestion is that you meet with an estate planning attorney. Many offer free initial consultation just to get the ball rolling, start that discussion. I know I do, and most do. You want to go to that appointment prepared, and the reason why I suggest you do that is make the most of the free time while you can use it. So what do you want to be thinking about and maybe even have written down is who you would want to be in charge of your affairs when you're gone. Where do you want those assets to go? And I always tell people, don't think lump sums, think percentages or fractions. Let me give you a quick explanation why. In Massachusetts, if you die in a nursing home, you're allowed to have $2,000 in assets. And the proverbial example is, I want to leave some money to my godchild. And they usually want to leave $5,000 or $10,000. So let's say you leave $5,000 to your godchild. You die in a nursing home with $2,000. The rest of your estate is supposed to go to your children. When you die, the $2,000 is going to go to your godchild and nothing's going to go to your children, because under probate law, specific bequests, a specific amount of money, a car, a piece of jewelry, certain stock, have to be fulfilled first before the general residuary distribution, we call it. Everything else gets split between my kids. So your $2,000 that you had for the nursing home is going to go straight to the godchild who's getting $5,000, which is why I usually say instead leave the godchild 1%, so they get something, so that they know you haven't forgotten them and you're thinking of them, but not a specific amount. For that reason, because we talk about percentages and fractions, you want to have a list of what your assets are. Some attorneys are going to give you an intake form, but they're going to want account numbers, balances, where the accounts are held. Excuse me. I certainly don't do that, and I don't do it in initial consultation anyway. But you might want to have that prepared, so when you're talking about fractions or percentages, if you say you're going to give someone 10%, you can look at the sum total and know what 10% is. If you own real estate, it's a good idea to bring copies of the deeds with you, because sometimes the nature of the ownership of the real estate will determine where that real estate is going to go at the time of your death, and your estate plan can't do anything to change that. If you have accounts, bank accounts or investment accounts, it's also a good idea to sometimes bring copies of those statements with you, because by looking at the statements, not the amounts, but how the accounts are held, we can determine the nature of the joint ownership, if any, and we can determine whether or not there are any named beneficiaries on those accounts. But remember, that first appointment is not the end. You're not even close to done. You're not done until the documents are prepared and executed by you in accordance with the legal requirements for their execution. A draft or an unsigned document is not of any probate value. It cannot be admitted to probate. It is of little evidentiary value at all in a probate contest. Whatever you sign, with some exceptions, can be changed. So it's important, even if you're just leaving for that trip to Florida and you want to get something in place, but when you come back, you're going to tweak it a little bit, make it a little better, get that thing in place. Just having a draft ready and getting on the plane, not good enough. You need to actually sign it. Now, a lot of attorneys will make accommodations for you that you go on that trip, when you come back from the cruise, come in and see me, we'll just tweak the will. I'm only going to charge you once, which is only reasonable. And it's something you can certainly ask an attorney about if they don't volunteer it. Like I said, whatever you sign can be changed with some exceptions. Wills can be completely revoked, or they can be changed paragraph by paragraph through a document called a codicil. You can have as many codicils as you need. As a codicil essentially says, take paragraph 1 out of my original will and replace it with this new paragraph 1. Sometimes when you have too many changes to be made, we'll recommend that you revoke the will and just execute a new will. Or sometimes if you're making a significant change that is going to basically take someone out of the will, we'll still recommend that you revoke and do a new will. A revocable trust, and I'll explain these terms a little more in a little more detail later. Revocable trust can, by its term, be revoked, or can be amended by amendments, documents called amendments, which are just like codicils. Replace section 1 with this new section 1. An irrevocable trust can be decanted, and I'll explain that in a minute, but it cannot be altered absent a court order. In other words, you can't decide you're not happy with the terms of your irrevocable trust and say, I want to make a change. And my war story for that one is a sad one. A gentleman who came to see me who owned 3 apartment houses, he wanted to leave 1 to each of his daughters. I made sure that's what he wanted to do. You're not going to change your mind. You're sure? Yup, everybody's stable, no problems. Well, after he came to see me about 6 years later, he came back and said, one of my daughters just went off the rails. She got a divorce. She's dating a guy who's a drug addict. She's an alcoholic. I need to take her out. And I had to break the horrible news that you can't. Court order, you really can't. There is something called decanting, which is essentially if you have an irrevocable trust and the law changes, the Medicaid law changes for qualifying for long-term care assistance, or the tax law changes, you can decant from one irrevocable trust to another irrevocable trust, as long as you give yourself the power to be able to decant. But again, that's not going to help you change beneficiaries. It may allow you to change trustees with some limitations, but it won't allow you to change beneficiaries. Whoever you named originally, you're taking what is in your irrevocable trust. Can you prepare your own documents? Yes, you're not required to use an attorney's assistance, but I suggest first you call around to see the best fee you can find from an attorney. And I always recommend go local, because it's likely to be less expensive in a local community than in a larger community because there's less overhead. The same will is gonna cost you a lot less in Uxbridge or Blackstone than it's gonna cost you in Worcester or in Boston. So just think about that. You also want to consider the costs if you do your will incorrectly. You may think you have a will, but if you don't have a valid will because you didn't comply with the Massachusetts will execution requirements, you're dying without a will, even though you may think you have a will in place. Massachusetts in particular does not recognize what they call holographic, which is a handwritten will. Your will has to be typed. My personal favorite, Susie Armand. Oh, Susie. Her program does not produce wills that comply with the will execution requirements in every state. It tries, but it doesn't. And also her trusts do not really cover all the bases either. So a lot of people like the Susie Armand products. Certainly something to look at, do your research, have some idea of what things are all about. She's a great fan of trusts, I know that. But I wouldn't go with her document as the final document, or what you can do is buy that and then ask an attorney how much they're going to charge you to review that document to make sure it does comply with the requirements. I've done that before at less cost than a will. And often I'll do it as an initial consultation for free. And then tell them what I think the potential shortfalls are. At least you'll know whether or not you want to proceed with Ms. Ormond's trust form or will form. The will my only choice? Well, no, but there are basically two estate planning choices in terms of what happens when you die. A will, which is a document drafted and executed in accordance with probate law, which appoints a personal representative to manage your estate, marshal your assets, distribute them to the persons entitled as directed under your will. But probate is required for a will to be effective. The alternative is a trust. A trust is an entity which is established by you by an agreement that you draft and sign, into which you transfer all, if not all, almost all of your assets, which then distributes those wills as you direct upon the happening of a certain event, which in most cases is your death. The advantage of a trust is it doesn't require probate for those assets to be transferred from the trust to your beneficiaries. So a lot of people like the fact that there's no probate court involved. You avoid all the probate costs, and it's a more orderly and a quicker distribution of your estate. It is available. General information on wills. Again, a will must be written. It must be signed by you. And it must be signed in the presence of two witnesses who will also sign, and a notary public who will sign the affidavit of proof. So 4 people are required. You, called the testator, the person who signs the will. 2 witnesses who cannot be related to you and able to inherit under your will, or if you died without a will. So it can't be your wife, it can't be your daughter. So it's usually 2, it can be your neighbor as long as they're not inheriting from you. 2 disinterested witnesses and a notary public, 4 people in the room. Identifies your personal representative, formerly known as your executor, who gathers your estate, delivers them to your successors, the beneficiaries under your will. That person also has the authority to sell those assets if the will permits it in a goodwill will, or with a court order if the will does not, or if you die without a will. And to use those funds to pay any of your final bills, as well as the cost of the administration through probate of your estate. A will is generally cheaper to prepare than a trust. Usually be done for a few $100s, maybe even less if you shop around. However, the cost of probate after you die might be a consideration because the filing fee for probate is $390. So you may pay $200 for your will. You're going to be, you know that your heirs are going to be paying out of your estate funds an additional $390 to file, plus the advertisement, plus counsel fees. So you have to anticipate probate costs of about at least a few $1,000s, which when you add to the cost of the will probably be more than a trust. But a will is a great option for somebody who is cash poor and is not really wanting to spend what they have available in cash on an estate plan, with the understanding that when you don't need the money anymore, you don't care if your beneficiaries are going to get a little less because of the cost of probate. It's less out of your pocket at the moment. And a lot of people do feel that way. Pros of a will versus cons of a will. A will is generally less expensive to prepare. It's something that people feel more familiar with as a concept. And therefore, they feel more comfortable executing a will. The con is the cost of probate is expensive. Another con is the loss of privacy associated with the probate process. We haven't discussed that in detail yet, but when you file a probate petition, you have to indicate what your estate is valued at, which means that nosy neighbor can now go, if they're so inclined, to the Worcester Probate Court, ask to see your file, and see exactly what you owned at the time of your death, what it was worth, and who's entitled to receive it. Sometimes people don't want that to happen for very legitimate reasons. Sometimes people just don't want their privacy invaded, and therefore they're not interested in the probate process. Another con is there can be a delay associated with the probate process. After complications, most estates are through the initial stages of the probate process within the first month after the decedent's death. So there's not as much a delay as you might think, but a probate estate does remain open for at least a year after your death for those creditors to be able to file their claims. And if we're not sure, if the personal representative isn't sure what claims are going to be coming in, they may have to withhold some distribution to the heirs of the estate, hold some money back in the estate account to pay any claims that might come in, or they're going to distribute it and be looking for you to give it back, which is not what we as lawyers recommend that they do. Excuse me. A trust is an alternative to a will. Trust is established by drafting an agreement. The trust is intended to own whatever assets you place into it. The person who sets up the trust, you, is called the settlor. The trust is also given a name. For example, the Kapiskas family trust. The trust will name a trustee who will be in charge of managing the assets for as long as the trust exists. Initially, that is usually the settlor, so that you can be in charge of managing your assets for as long as you're alive. But then you would name a successor trustee. And that person acts much like an executor or a personal representative who will see to the distribution of the assets in the trust per the terms of your trust when you pass away. An estate planning trust is designed to end at the death of the settlor when the trust property would be distributed to the trust beneficiaries, but that doesn't have to be the case. You can have a multi-generational trust, but there are some tax implications associated with that. Pros of trusts: provides as much privacy as possible, as opposed to the probate process, because there is no probate process in most trusts. Another pro: trust assets are immediately available to be distributed in accordance with the trust terms. You don't have to wait for creditors to file claims. There's no creditor claiming process through the trust process. Another pro is that a trust is usually harder to contest than a will, because it usually requires the commencement of a lawsuit and more money up front by the person who's going to contest it. Another pro is the avoidance of duplicate probates if you own property in more than one state. It's not uncommon, for example, where I practice in Rhode Island, for many people to own property at the Cape as well. Even if it's a timeshare, it's considered real property. And what they don't realize is when they own that timeshare in another state, that they're going to have to probate the estate in both states, the state where they died resident and the state where that other real estate sits. So if you have a condo that you live in Florida for 4 or 5 months out of the year, and you own that condo, a trust might be worth it to avoid having to probate your estate both in Massachusetts and in Florida, because probate jurisdiction is what we call in rem. It's wherever the property sits. So you would have multiple probates if you own property in multiple states. Cons of a trust. A trust is more expensive to put in place as an estate plan. You can expect costs of at least $1,000, maybe more, especially more if you own multiple parcels of real estate, because there'll be multiple recordings associated with the transfer of that real estate into the trust. Another con that I've seen with a lot of people is a trust is a much longer document than a will, and it looks a lot more complex, but it's really not as complex as it appears. You're essentially creating a probate estate by agreement. So you have to put in place any possible contingency that could come into play. All authority the trust can have to deal with those assets: the authority to sell, the authority to manage, the authority to make investments, so on and so forth. So it looks more intimidating because it's longer, but it's not really all that more complex. And I often provide my clients with what I call cliff notes. so that they can know which paragraphs are the important ones for them to look at, to focus on when they're really reading that draft. In terms of trust, there are essentially two types, revocable and irrevocable. A revocable trust is just what it says, a trust in which the settlor in the agreement itself reserves the right to amend the trust or even completely revoke it at any time as long as they are both alive and competent. That makes a revocable trust more like a will because it can be changed at will at any time before your death as long as you're competent to do so. An irrevocable trust does not really offer this flexibility. Once a trust agreement is signed and assets are transferred into it, that's called funding the trust, it becomes irrevocable in that the settlor cannot change its terms, cannot decide to take back assets from a trust, or revoke the trust completely absent a court order. That's why an irrevocable trust, as I say to people all the time, is written in cement. And it's very hard to break, and the only person that really has the authority to break it is a judge. So why would anybody want an irrevocable trust? Well, the short answer is most people want it for long-term care planning. Long-term care assistance, the program that's set in place in the Commonwealth of Massachusetts that will help pay the expenses of long-term or nursing home care, excuse me, is asset-based, and it depends on what your assets you have and to some degree what you've given away to determine whether or not you qualify for long-term care assistance. The long answer is most people considering estate planning also want to prepare for the chance that they might need long-term or nursing home care later in life. So as a result, the estate planning discussion often runs hand in hand with the Medicaid or Mass Health qualification discussion, because you can use an irrevocable trust to try to shelter assets from the expenses of long-term care, as long as you're willing to give up access to those assets for as long as you're alive. So how does one qualify for Mass Health to pay for long-term care in Massachusetts? Every state has a Medicaid system that provides health care at no or reduced cost to those who meet certain medical and/or financial criteria. In Massachusetts, to receive long-term care or nursing home assistance, you must qualify both medically and financially. To qualify medically, the agency will review your medical records to determine whether your condition is such that you require that level of care. It's a stepped-up level of care that a nursing home provides. Stepped up from assisted living stepped up from independent living. Nursing home is the highest level of care that's required. You can't go to a nursing home just because you don't want to live at home alone anymore. If you can't live at home alone because it's unsafe, that's a different level of care requirement. But if you're bored and simply want to live in a more active environment, then you would not qualify for Medicaid, or in Massachusetts called Mass Health, to defray the cost of your independent or assisted living. One exception is veterans. Veterans can get benefits to pay for assisted or independent living. In order to qualify financially, the agency will review your financial records to determine whether you truly lack sufficient funds to pay for your own care, because the bottom line is the Commonwealth of Massachusetts does not want its taxpayers paying for your care if you have the ability to pay for your care. So to be medically qualified, you have to meet, there are various levels of care as I just described, and you must meet the highest level of care to qualify for Mass Health. Most elderly persons in need of this level of care usually have a substantial physical or cognitive deficit, which makes it unsafe for them to reside at home, or which makes the cost of them living at home and those services coming into the home more expensive than providing that care in a nursing home setting. And it's important to remember that Mass Health is not limited to the elderly. It's also available to other people who might need assistance, such as those with disabilities. To financially qualify for Mass Health, you have to demonstrate that your assets put you at a certain poverty level as to require financial assistance to be able to pay the level of care needed to keep you safe. The application is designed to drill down and seek out any wealth you might have that's available to pay for your care privately. You're required to spend down your available, and that's in quotes for a reason, assets privately paying for your care before Mass Health will step in and pay for that care. And the Mass Health application is designed to seek out those available assets. Only assets that are deemed available are susceptible to paying for nursing home care. There are certain assets that are not available. What assets are available? Cash, bank accounts, stocks, bonds, real estate. In Massachusetts, unfortunately, retirement funds. Cash value of life insurance policies, motor vehicles, boats, planes. Bottom line is, if you can spend it, the Commonwealth says you can spend it on your care before they're going to pay for your care. Understand too, and this is another misconception a lot of people have, that if they own things jointly, that if they put their 3 kids on the bank account with them, they each own a quarter. And therefore, because they each own a quarter, they can only take a quarter to pay for mom's care in the nursing home. And that's not true. Every state's regulation provides that if mom's name is on the account, it's presumed to be mom's. And 100% is available to pay for mom's care. And that's an even more important thing to remember. If you have your mother's name on your bank account, unless you prove to the Commonwealth of Massachusetts that the money in there is yours, it's presumably your mother's and available to pay for her care. How about that? How much can you keep? In order to qualify for Mass Health Long-Term Care, that's what LTC stands for, you must spend down those available assets to $2,000. If you're married, your spouse is allowed to keep up to $128,640 if that spouse is living at home and not receiving long-term care assistance as well. So if you have $200,000, spouse gets the first $128,000, you get the rest. You have to spend yours down to $2,000 before Mass Health will begin to pay for your care. Now, there are legitimate things you can spend down on. The first is you can prepay your funeral. I always tell people, if on the eve of anyone going into a nursing home, that's an important thing to do. In fact, I discuss it with people when we sit and talk about estate planning. It's not a bad idea to do that in advance. Unfortunately, we've all heard of nursing homes that are taking advantage of that, and the states have done their best to tighten those requirements. Nobody can give you any promises, but that is a great way to spend down. So if mom or dad's on the eve of going into the nursing home, prepay the funeral, but the cost must be reasonable. In Rhode Island, we have a case that actually says a funeral that cost $18,000 was reasonable. It's not the case in Massachusetts. They would not view that as reasonable. I think anything under the $12,000 range might be reasonable in Massachusetts, but again, depending on your locality, because $12,000 in Boston is different than $12,000 in Bellingham. Another thing you do is set up a burial account that's capped at $1,500. You can also spend money on items that are needed to make the resident more comfortable in long-term care, like a large screen TV or headphones, wireless headphones, or one of the recliners that lifts to help them get in and out. Prepay a one-year subscription to a favorite newspaper or magazine, or prepay a 1 year of cable or telephone services or cell phone services. Purchase them a cell phone. Another thing we're seeing a lot of, especially now, it's becoming even more relevant, is the purchase of a laptop computer or an iPad, especially now, that may be the only means of communication while people are in nursing homes during COVID-19. In addition, if the spouse is going to continue to live in the marital home, and they're alive and they continue to live in the marital home, you can make necessary home improvements to the marital home. Put a new roof on it. Does it need a new boiler? Could it use new windows or a paint job? Those are all legitimate spend downs, and you can pay, the resident in the nursing home can pay for half of those. What about my kids? Can't I just give it all away to them now? The short answer is no. Why? All state Medicaid programs that are funded by federal funds are required by federal law to have a look-back period. That look-back period is at least 5 years, but can be higher, subject to change by the state legislature. Massachusetts currently has a 5-year look-back rule, but 3 years ago, they were looking to pass a look-back rule that was going to be 13 years. When you consider most people that are looking at nursing home are in their 80s, that would mean you would have had to have done your nursing home planning when you retire at age 67, which most people aren't thinking about. And that's an awful lot of time to cut yourself off from a lot of your assets and figure out what you can live on for the rest of your life. It's kind of a scary prospect, but luckily it didn't pass. It's still 5 years. Part of the Mass Health application, the applicant is asked, have you transferred out any assets to a person or a trust for which you received nothing in return? That's the legal definition of a gift. For the last 60 months, which is the equivalent of a 5-year period. If you answer that question, yes, you have made a gift. By the way, that Mass Health application is signed under penalty of perjury. And because of the sums of money we're talking about perjury that would be a felony. So if you lie about a gift and they discover that you've lied about a gift, you can be charged with felony, which is another reason why I always suggest have the applicant sign the application if they're able to do it, because they're going to be a lot less likely to put your 88-year-old mother in prison than they are to put you in prison because you signed mom's application. For every gift that the applicant has made within that 5-year look-back period, the applicant is assessed a corresponding period of disqualification. That's the period of time for which the Commonwealth will not pay for your care in long-term care. A period of disqualification is determined by dividing the value of what you gifted away by the average cost of monthly cost of a nursing home in the Commonwealth of Massachusetts. The result is a number of months that Mass Health will not pay for your care as a penalty for that gift. The average monthly cost for long-term care in Massachusetts is currently approximately $12,000. That's determined every July, so the figure changes annually, but right now that's what it is. So for example, if you gave away $25,000 to your child, the Commonwealth, and then applied for long-term care assistance because you only have $2,000 left, the Commonwealth will assess a penalty of 2 months and 22 days. Is that what I have? Yeah, 2 months and 22 days, because that's how much the $25,000 would have paid for. And yes, they do break it down to days. What happens then? You've made a gift, you're assessed a period of disqualification, who's going to pay for your care? If you're applying for Medicaid, you're already down to $2,000. You don't have enough money to pay for your care privately for that period of disqualification. So you have essentially one choice. Go back to the person you gifted the asset to and tell them you need it back to pay for your care. If they don't have it, or if they refuse to give it back, which certainly does happen, sadly, yeah, and you can't find another way to pay, the long-term care facility can and may evict you for non-payment of the facility. So if you get qualified for Mass Health, what's the ripple effect? What's the after effect? By accepting benefits, you agree that the Commonwealth of Massachusetts will have a priority lien, dollar for dollar, against your probate estate for every dollar they spent on your care during your lifetime. The exception is a family home is treated differently if you have a surviving spouse living in that family home. In Massachusetts, the lien cannot attach to a family home that has a surviving spouse living in it. However, if that surviving spouse either dies while you're still in the nursing home and receiving Mass Health, or also ends up in a nursing home on Mass Health, all bets are off. The home is susceptible to the lien. Before your heirs get whatever you leave behind, the Commonwealth first gets paid on that long-term care lien. That's why they are a priority. They take a priority over everybody but estate taxes, because that money is all going to the same place, back to the Commonwealth. How will Massachusetts know it's time to collect? Because as part of the probate petition that's going to be filed, you are required to give them notice that you have died. Your estate is required to provide a copy of the petition to probate and your death certificate to Mass Health so that they have the ability to step in and make claim for whatever lien is owed. This is part of why an estate plan is important. What does my estate plan have to do with it? The best nursing home planning you can do is done early because of that 5-year look back. It involves the complete divestment of any interest in all of your assets that you're looking to protect. And your plan may help determine what of those assets are available to pay for your care or not. If you have a will and all of your assets pass into your estate at death acted upon by your will has to be probated, and the Mass Health lien will be filed and will have to be addressed. If you have a revocable trust, Massachusetts case law and Mass Health regulations provide that any assets in a revocable trust are available to pay for your care while you're alive. So in other words, if you put all your assets into a revocable trust and say, I don't have anything, it's all owned by the trust, the problem is all the assets in a revocable trust are available because at any point in time you can say, I revoke my trust. The Commonwealth of Massachusetts will say, you get no Mass Health benefits until you revoke that trust and spend all those assets to pay for your care first. So does nursing home planning and estate planning go hand in hand perfectly? No. The problem is I was describing them as two trains that run on parallel tracks. You hope that they'd intersect at some point, and in the past they did, but as money gets tighter and tighter, the federal government tightens the requirements, and so does the state government tighten the requirements. They close up all those loopholes, and you're less able to protect assets. If you have an irrevocable trust, and that trust was established and funded at least 5 years, that 5-year look-back rule, before you seek Medicaid or long-term care assistance, and the state has not increased that look-back period to a longer period of time at the time you're applying, then any assets of the irrevocable trust are sheltered from the state's lien, provided you provide on the irrevocable trust that you're entitled to take nothing from the trust during your lifetime, and you cannot take assets back or even take interest earned on those assets back during your lifetime. Because if the trust provides that you can do either take an asset back out or you get some interest income, that is what you're allowed to take is an available asset, and there are consequences. Let me play out an example. A lot of people will say to me, okay, I want to protect as much as I can. I'll put it into an irrevocable trust, but I want to make sure that I'm going to have enough to live on. So I want to put in the trust that I'm allowed to take $10,000 a year, $2,500 quarterly. That sounds good. Here's the problem. If you end up on Mass Health, your assets have to be below $2,000 to qualify. So let's say on January 1 of 2020, you were below $2,000. Good, apply, get qualified, Mass Health pays. Second quarter rolls around. You get your $2,500 from your trust. You're now over assets again. You have to spend that $500 to get below the $2,000 to financially qualify for Mass Health, and then reapply. And that's going to happen every single quarter, because as soon as your assets go above the $2,000, you're disqualified, which is why that plan doesn't work so well. Usually what we suggest for something like that is some sort of backdoor where you provide that money is going to be paid out to your children. You make a private agreement, not memorialized anywhere, with your children that, hey, if I need money, that money is going to be available to me. Even better, give it that your children have the option to take it, so they can just let it sit there if they choose to do so. The other thing I want to mention before I get off this particular slide is that you notice I said that the state does not increase the look back period to a longer period of time. People think that if I do it now and the look back period's 5 years, I'm grandfathered. That's not the case. The look back period for you is whatever the look back period is at the time you apply for Mass Health. So if Massachusetts did pass 13 years, people who did estate planning 5 years ago thought they were all set. They're not, because at the time they apply, if it's 13 years, it's 13 years. You're not grandfathered. And that's a little bubble I have to burst for people sometimes, but it just is the case. What does all that have to do with estate planning? Well, a lot. Most clients I meet with want to do both, estate planning and nursing home planning. It's not easy to do both well and maintain the flexibility that clients want to have with estate plans. An irrevocable trust is a great nursing home planning tool, as I just described, but a poor estate planning tool because it's inflexible. A revocable trust is a great estate planning tool because it has a lot of flexibility, as much as it will, but it's a poor nursing home planning tool because it offers no protection to the assets in that revocable trust from the costs of long-term care. So which estate planning tool should you use? It depends what objective you're looking at. Cheapest upfront is a will. Flexibility, as times and people change, is a will or a revocable trust. Avoidance of probate, a revocable trust or an irrevocable trust. Privacy, revocable trust or irrevocable trust. Nursing home planning, a revocable trust or deed. Wait a minute, deed. We didn't talk about deeds before. Let's talk about deeds. If you own real estate, the manner in which that real estate is owned is very important to consider. In its simplest terms, there's 3 types of ownership. One is as joint tenants. You each own an undivided share and each owner has a right of survivorship. So as each owner dies, the shares of the remaining tenants increase. So if there are 4 original owners, you each own 1/4. One of them dies, you each own 1/3. You're down to 2, it's 1/2. The last one standing owns it all. Tenants in common is pretty much the opposite. Each owns an undivided share, but there is no right of survivorship. So the share of each of them passes as part of their estate plan and controls where their share goes. And this goes back to when I mentioned that when you go to meet with an attorney for an initial estate planning consultation, this is why you should bring a deed with you. Because as you can see, if you're joint tenants, your will can't change what that deed's going to do. But if you're tenants in common, you need to provide in your will where your interest in that real estate is going to go. Now, there's a unique type of joint tenants called tenants by the entirety, and that's a form of joint tenancy that's unique to spouses only, and the rules are the same as with joint tenants. Can I use deeds in estate planning? You can, but there are risks. A lot of people tell me, I want to transfer my house to the children. That's fine, but you need to understand, and I tell them my horror stories, that that house is now their house, not yours, with all that entails. They can mortgage that house. They can sell that house. They can kick you out. If they end up in bankruptcy, your house is part of their bankruptcy. If they get a divorce, your house is part of their divorce. If they owe a whopping tax bill to the IRS, your house is subject to the IRS lien. It's not your house anymore. It's theirs. Other people say, well, I'll just add my children on. So they're additional owners. So when I die, we can all be joint tenants, and when I die, they'll all own it. Well, that's fine, but it makes them co-owners. And that means that if you decide, hey, I want to downsize, you have one of those particular children that says, no, I kind of want to be able to buy the house when you're dead because I'm going to be in a better position financially. They can refuse to sign off on the deed that would allow you to sell. And also if they're co-owners, if you sell and they refuse to sign a deed transferring it all back to you, when you sell, they're going to get a check at your closing too. If there's 4 of you, you're each going to get a check for 25%, and that may be not what you wanted. There's another type of deed called the life estate deed. A life estate deed is where you transfer your house to your children, but you retain for yourself what's called a life estate, the right to live there for the rest of your life. So as long as you're alive, the house is yours, and immediately at the moment of your death, by operation of the law, the house becomes your children's. For Rhode Island, that's a very effective tool for long-term care planning. In Massachusetts, it is a completely ineffective tool for long-term care planning. So if someone suggests that to you, remember I said that a life estate deed does not work in Massachusetts for nursing home planning. It's still a perfectly good estate planning tool, but it is not a good nursing home planning tool. Other estate documents you might want to consider, and these are more for while you're still alive. In the Commonwealth of Massachusetts, you have a document called the healthcare proxy, or a healthcare power of attorney. It's used to appoint up to 3 people in succession, 1, 2, 3. They call 1, then they call 2, then they call 3. And they're authorized to make healthcare decisions for you in the event you're unable to make them for yourself, and only in those circumstances. The document should include instructions in writing to that person appointed to help guide them in making decisions that are in accordance with your wishes. And they're usually end-of-life issues, whether you want to be resuscitated, whether you want chest compressions, whether you want artificial feeding or artificial hydration. And those are all important factors to consider. In fact, you might want to consider it, and the form usually does in the form of a checklist. Under these circumstances, what would I want done? Under these circumstances, what would I want done? Another document is a durable power of attorney. This is a power of attorney that names an agent, 1 or more persons, or an attorney, in fact, who are authorized to act in your name and in your place in all matters except for healthcare, as are detailed in the document itself. The document sets out the powers that they have, and the person you appoint has the power to act in those particular areas in your place as if they were you. Most powers of attorney are drafted very broadly so as to include as many powers as possible so that they'd be able to act as necessary in your best interest. The 2 types of powers of attorney are durable and springing. A durable power of attorney is valid the moment you sign it. The moment you sign it, that agent, that attorney, in fact, has the same legal authority to act with regard to your assets as you do. And the springing power is a little different. The springing power provides that it's valid only upon the happening of a certain event. What my clients are usually looking for is such as a disability. You're unable to act in your own affair, in handling your own affairs. That's usually disfavored by most estate planning attorneys, including me, and let me tell you why, because it sounds like what everyone wants. Here's the problem. Think of the bank that you've dealt with that is the most difficult bank to deal with in your life. For me, I have a bank in mind. Now, I give someone a power of attorney for me. It's a springing power upon my disability. They present my power of attorney to the bank. Bank's going to look it over. They're going to send it to the legal department. The legal department's going to say, we need proof of the happening of that event, your disability that makes you unable to handle your own affairs. So now the person you gave your power of attorney to has to go to your doctor and get documentation to prove that you're incapacitated. And they have to provide that document to the bank or the financial planner or the legal department at the bank, where your medical record now becomes a permanent part of your banking record. I don't like that idea. You shouldn't like that idea. And one of the main reasons you shouldn't like it is the loss of privacy. But the bigger reason is, what if the legal department looks at it and says, it's not enough, we're not going to let you act under the power? And it happens. So that's why I disfavor springing powers. You can think you have it all set up and you don't. Because all of a sudden, there's some legal lawyer in Boston is saying, no, this doesn't meet the qualifications under your power of attorney. It's not a sufficient disability. And your money's tied up and you can't pay your bills. And now your agent can't pay your bills on your behalf. It's a pretty terrible situation. Another document I want to think about is a HIPAA authorization. We've all heard of HIPAA. HIPAA is a perversion of what it was supposed to be. It was intended to be a federal law to protect doctors who transmit your records electronically, because that's what Medicare requires now. If they transmit it to the wrong person, they can't be sued for violating your privacy rights, the doctor-patient privilege, because they accidentally sent your electronic record to the wrong place. That's all HIPAA was designed to be. It's been perverted into a different type of privacy law. But essentially what's going to happen is, let's say you appoint someone for healthcare proxy. There are doctors and hospitals, there have been, that have said to the agent, well, we need you to make a decision whether or not we should pull the plug on mom. Well, can you tell me what her prognosis is? Can't do that. HIPAA. It happens. I can't believe it happens, but it does. So as a result, I usually suggest you might want to talk to your physicians so that you can authorize a trusted person that is able to discuss your medical care with that physician in the event there are any questions, or for example, if they need to qualify instructions that were given to you. Sometimes a doctor can give you a medication that has an adverse reaction. You're not capable to call the doctor and say, I'm not feeling good because of this medication. You could authorize this person to be able to talk to the doctor and say, hey, she took XYZ pill and now she's having the following symptoms. Or how often is she supposed to take it? She's not sure, which is more common with the elderly that get instructions confused. There's also something called the global HIPAA authorization, which basically authorizes someone who has a healthcare proxy or a power of attorney to be able to talk to any of your physicians about anything with regard to your medical care. And that's something else you might want to think about. Some attorneys draft those, I know I do. Another thing is not really legally binding, but it's really a courtesy. It's not a bad idea to leave behind your personal representatives or your successor, a list of all the assets you own. And that's a list that you should update each and every year to the extent that anything changes, so that your executor or your power of attorney can have a starting point to hit the ground running in either the management of your estate when you pass or the management of your affairs if you're still alive. Because I'm in this situation right now where I'm assisting a client who asked me to, I know she's no longer my client, she asked me to act under her power of attorney because she has no family. And I have no idea where she has assets. And I'm essentially now charged with going from bank to try to discover if she has an account there. And these days of COVID-19, that's not something you can do in one day. You have to schedule an appointment and get all gowned up and go in and get authorized to go in and enter. And it's a complex and difficult task. And it's much easier for those who are left behind if you leave them with that letter of instruction. Once I do all this, I'm all done, right? Once I have my estate plan signed, sealed, and delivered, no, you're not all done, not quite. You should really review that estate plan at least every 5 years. It's better if you can do it annually, and I usually suggest to my clients, tax time's a great time to do that, because you're already looking at all your financial documents anyway. Some other important triggers that you should look at your estate planning documents is certain events, such as a marriage or a remarriage or a divorce. For example, in Massachusetts, as in Rhode Island, a marriage or a divorce revokes a pre-existing will. So it's important to remember that. Subsequently born children or grandchildren who may not be included in the will, you might want to amend the will to include them. If you acquire large assets, like you buy that retirement condo in Florida or the ski chalet up in Vermont, or you sell large assets, you jettison the boat or you jettison the Florida property. If you inherit something that you might not have anticipated and didn't include in your original estate plan, a change in the law, particularly a change in the Medicaid law or the estate tax law, might require you to make some shifting in your estate plan. And the big thing that usually causes changes in wills, it's been my experience, is fights, big fights in the family. All of a sudden, one child's not talking to you, one child's not talking to the other child. You don't want the child that's being difficult to be the executor of your estate. You want to change it. All of those are trigger events which should make you at least look at your estate plan and think about making changes. A few more random thoughts. If you have any potential heirs that have disabilities, a child or a grandchild, you might want to consider a special needs trust. This is a means to give them something in your estate that will not have them lose their asset-based benefits that they may be receiving. For example, I use my family as an example. I have a child with autism. Although I would love to leave him 50% of my estate along with my daughter, I'm hesitant to do so because although he's not receiving any at this point, he may be receiving asset-based benefits like Medicaid, we call it here in Rhode Island, Mass Health in Massachusetts, at some point in the future. Therefore, his 50% of my estate is left to a special needs trust that his sister will be the trustee of when I'm dead. And she will manage those assets. And as long as she doesn't use them to pay for things that Medicaid will pay for, it doesn't affect his ability to collect those asset-based benefits, like math, health, food stamps, whatever the case may be. If the heir is a grandchild in particular, I would suggest that you ask the parent if they've already established a special needs trust for the child. They may have already done so as part of their estate plan, and then you can simply leave whatever you want to leave to that grandchild to the already established special needs trust. I would need, or any attorney would need, the name of that trust and the date it was established in order to include it. Another big question that always comes up. Massachusetts does allow trusts for pets. You can identify a trustee and a caretaker, as well as provide funds for the care and support of a pet through a pet trust. Rhode Island is not as progressive. In Rhode Island, pets are still treated as personal property that you leave to someone. Massachusetts does have what they call a small estate process. And again, whether you die with or without a will, if you die with $25,000 or less in your estate, and for most people, what we usually say is, if you set up a trust, put everything in the trust but your car. Let me tell you why you don't put your car in the trust. Because my insurance friends tell me, if you put a car in a trust and the car is owned by the trust, but the operator is somebody else, the risk is higher because now the operator is different from the owner. So as a result, your premiums usually go up. So we usually tell people, leave your car out of your trust. And unless you own a brand new Maserati, most used cars that elderly people are driving are worth less than $25,000. The typical one around here is the Buick Skylark. You can use a small estate process to transfer that motor vehicle. It's a little cheaper than probate because it's a $115 filing fee. And it's a summary process. You file the paperwork and they send it back to you stamped, you can transfer the car. You don't have to go do anything else in the probate. You don't have to file any closing documents, nothing like that. It just gives you the authority to deal with small estates. And this is usually the process we use when someone dies in a nursing home and their assets are worth $2,000 or less. And it's designed to deal with those small estates that shouldn't have to pay $390 to be probated. This is my contact information. Now you see I have a PowerPoint that I've presented. If anybody would like a copy of this PowerPoint, if jot down my email, shoot me an email and I'd be happy to send it to you sometime this week. As soon as you shoot me the email, I'd be happy to send it to you and provide you with a copy of the PowerPoint for your records. And at this point, I guess we're going to open it up to questions.
Okay, everyone, at this point, if you have a question, please do indicate so by raising your hand. Again, you can find that option in the participants window. In the meantime, Lynn, we had a couple questions come up in the chat box. So I'll go ahead and read those questions to you and maybe you can answer those for us. Our first question is from William. It says, for assets that are owned jointly with a spouse, do those assets go to the spouse?
It depends on how they're owned. There's a presumption in the law with regard to joint accounts that the joint account does not necessarily go to the joint owner unless you state that that's your intention. So if you have a joint account at a bank, for example, most banks include in their language that the joint account asset goes to the person who's named, the joint account assets go to the person who's named jointly on the account. In that instance, they do. But trust me when I tell you that joint accounts are usually the biggest source of fights in probate, because not between the spouses, but when one spouse dies and they name the trusted child on that account, and suddenly the trusted child, when mom dies, says all the money is mine, and everybody's at the funeral home doing the planning and no one can find Susie. Guess where Susie is? She's going from bank to bank. So as between spouses, it's usually not an issue, because quite frankly, your spouse is entitled to 50% of your estate if you died without a will. And in most cases, if you died with a will, 100%, so it doesn't really make it an issue. But bank language will determine it. And with regard to stocks and other assets, if it just says joint tenant, it's not automatic. If it says joint tenant with right of survivorship, JTWROS, it is automatic. It does go to the spouse.
Okay. All right, William, I hope that answered your question. If not, raise your hand and we'll see if we can answer a follow-up to that. Our next question is from, looks like it's a public library. Oh, sorry, I think that says Paula. But anyway, this one says, are wills created through an online service like Law Depot valid? It says valid in the, and I'm assuming it means in the state courts.
A will from any source is valid as long as it complies with the requirements of state law. And the main requirements of state law are it needs to be signed by you, the person creating the will, 2 witnesses who are disinterested. That means they're not going to take anything as a beneficiary or successor under the will, and they would be entitled to inherit from you if you died without a will. So that intestate succession law. And they sign an affidavit. It's not required, but it's recommended you sign an affidavit of proof, all 3 of those people, in the presence of a notary public. My problem with them is they're not usually well crafted and well drafted, because essentially you are answering questions and the form simply fills in the blank. I would again suggest, while they're valid, you might want to run it by an attorney who's going to charge you less than they're going to charge for a regular will, may not charge you anything at all, to tell you whether or not it would meet the requirements of the law. It's better to know than have you die and find out it wasn't good and you died without a will.
Sure. Okay. Again, if anybody has any follow-ups to that, let me know. Our next question in the chat box was, what if your spouse died over 15 years ago and you did nothing of this for a will?
You did nothing to probate a will?
I'm assuming so. Again, this is in the chat box, so
okay.
Let's go with that, and if it needs more follow-up, we can ask her for more follow-up.
It means essentially if assets were jointly owned and you simply took control of those assets, it's not a problem at all. The only problem might be if those assets included real estate with regard to that estate tax lien. And there is a statute of limitations on estate tax liens. In Rhode Island, it's 12 years. In Massachusetts, I believe it's 20, so you're close to that period. But if you were to pass away before your husband or spouse has been dead 20 years, and an estate tax lien is still existing on that real estate, your heirs would have to file an estate tax return for your husband's estate who died 15 years ago, as well as your estate who died now. And quite frankly, 15 years ago, I don't necessarily recall off the top of my head what the exemption was, but it might have been less than $1 million, and there might be estate taxes owed.
All right, if there's any follow-up questions to that, let me know. Our next one says, why do you say a life estate is useless for Massachusetts? My understanding is that they get a stepped up in basis and let's see. Oop, I lost it. They get a stepped up. Oh, you know what? It looks like the rest of that cut off, but it says, well, maybe you could just answer why are you saying that it's useless in Massachusetts?
It's useless in terms of nursing home planning. That's what I was wanting to emphasize. If I misspoke, I apologize.
Okay.
It's a useful estate planning tool in terms of a step up in basis, the avoidance of probate with regard to the transfer of the real estate because it passes by operation of law. But in terms of a nursing home, in Rhode Island, essentially, if you create a life estate deed outside that 5-year look back window, so in other words, you've created a life estate deed 6 years before you apply for long-term care assistance, that in Rhode Island, that real estate is exempt. They can't get at it at all. It's not an available asset. They can't lien it. In Massachusetts, a life estate interest is a lienable interest. So in other words, they will require you to liquidate it and use its value to pay for your care before you would qualify for Mass Health. So it's only useless in terms of qualifying for Mass Health. As an estate planning tool, it is still a valid tool.
Okay. And then looks like the last text question I have is, S corporations have special considerations?
I'm sorry, I missed the first part of that.
I think it says, do S corporations have special considerations?
They have special tax considerations in terms of taxes, both alive and dead, and that you need to run by an accountant because I'm not one and I'll freely admit that. But a lot of people do use S corporations as an estate planning tool to manage estate assets. If you have a sizable estate, the use of corporations is not uncommon. Akin to a trust. Basically, you're setting up a business that will own your assets and distribute those assets to your heirs. It may transfer shares during your lifetime. It may transfer shares over in an orderly period of years, or it may transfer an outright transfer when you're deceased, or maybe even passing shares for years after you're deceased. They can be used in estate plans, absolutely.
Okay. All right, if there's any follow-up to that, let us know. And then we also have a question, looks like from Susan. Susan, if you are ready, I'm going to unmute you. Let me know if you can go ahead and talk.
Oh, okay. Hi. If a person has all of their assets owned by an irrevocable trust, then how do they access those assets to live off of?
If you have all your assets in a revocable trust, you are typically the first trustee of that trust. As the trustee, you have the ability to access any of those assets in the trust as long as the trust provides for that. So essentially, it's as if you still own the assets. It simply provides, the trust simply provides for what happens to those assets at your death, that they never become part of your probate estate.
No, I'm sorry. I meant an irrevocable trust.
If you put assets in an irrevocable trust, they are 100% unavailable to you to live on during your lifetime, unless you provide in the trust that you have the ability to take assets out. If you provide, you have, and you can do that. You can absolutely do that in an irrevocable trust. You can provide that you're entitled to take a certain amount of money out annually, quarterly. You're allowed to take all the interest out. The only concern is in terms of the joint view of both nursing home planning and estate planning. Whatever you're able to take out is treated as an available asset to pay for your care in nursing home planning. But as long as you provide in any trust, whatever right you want to have, you can give yourself. But there's a counter effect in terms of nursing home planning with regard to an irrevocable trust, that any asset you can take is available to pay for your care. Did I answer?
I think so. Yeah, thank you.
Okay, great. Anybody else have any more questions? I don't see any more raised hands at this time. And it doesn't look like there's any more.
I have one.
Okay.
Is there a problem with having a revocable trust that owns real estate in 2 different states?
No, actually, that's an excellent way to estate plan for real estate in 2 different states because you avoid duplicate probates. All of my clients that, and it's not uncommon here in Rhode Island, which is the lion's share of my practice, that people own properties in Maine, New Hampshire, Florida, or the Cape. And it's not uncommon for me to recommend to them for no other reason than to avoid that duplication of probate to do the trust. Yes, the trust is more costly upfront, but it's still going to be cheaper than probating in 2 states. And it's a much more effective, orderly transfer of your assets.
Okay, let's see. It looks like there might be another one in the text message. Let's see. Are there any issues in terms of inheritance if your children live in a different state than you?
The only problem there might be is if they live in a state with an inheritance tax. There are about, like I said, about 8 or 9 states that still have inheritance tax laws. If they live in a state where there is an inheritance tax, they would have to pay that inheritance tax. Other than that, there should be no other issues with a child that lives out of state.
Okay. And our last one on the text box says, if a lawyer begins the process of settling an estate for a descendant who had a will, then partway through triples his anticipated fee. Sorry, I'm having trouble reading this. Triples his anticipated fee. Apologize for that. I just went away from it. Okay, anticipated fee. What recourse is available to someone who didn't get what was in writing up front?
Essentially, I always tell any client that has an issue with any other attorney, or even with me, if you have an issue with a fee, if you believe that the fee agreement that you reached was deviated from, by example, you're saying that fee was tripled from what the anticipated fee was to be, depending on what your fee agreement said. You always have recourse. You could always sue the lawyer personally. You could object to the attorney's fee when the estate is finally settled, because most fees of both the fiduciary, the executor, the personal representative, and the attorney are subject to court approval for reasonableness. You could object to the fee at that time, as well as suing the attorney individually to recover whatever fee the attorney took. The best course is actually go to the disciplinary council for attorneys, which in Rhode Island is through the Supreme Court, and in Massachusetts is through the Supreme Judicial Court, through the Board of Bar Overseers. They have a procedure in which you can file a complaint against an attorney with regard to a fee dispute, and they will actually mediate that fee dispute for you with the attorney. It's usually a fill-in-the-blank form that you complete. They'll reach out to you, conduct an investigation, reach out to the attorney, and then they'll make a finding as to whether or not they think that there's a dispute that needs to be mediated. If they do, they will step in and act as mediators with regard to the dispute. The important thing is at no cost to you, which is why that is the best recourse, is to go through the Board of Bar Overseers. As attorneys, we hate it because they're disciplinary counsel and they're the ones that give us our slaps on the wrist. But it is the best way for you as a client to protect yourself if you're being gouged for a fee. And unfortunately, it does happen.
Okay. I hope that answered that question. Does anybody else have any further questions? Don't see any hands raised, and I don't hear anyone speaking up. I think at this point, we are done with our program. I just want to say thank you to everyone so much for attending today's program. We want to remind you that the program was made possible in part by the Institute of Museum of Library Services and administered by the Massachusetts Board of Library Commissioners. With that, I'd like to say thank you again to Lynn for her informative presentation, and thank you all for attending. Please check out the Blackstone Public Library's calendar of events page for further Zoom programming based on this LSTA grant. And thanks again, everyone. Be safe, stay well, and we hope to see you again soon. Thank you very much. Thank you, Lynn. Thanks so much.
Thank you.
Everyone.